Good evening, folks. Welcome to a special edition of Monday Night Law on Kirk's Law Corner. Going to go over a little history behind and surrounding the Declaration of Independence, because I think this is a very appropriate time to return to some fundamental principles and some declarations and the history behind the Declaration of Independence. This lack of knowledge of what the Declaration of Independence is really about, how it came about, boggles my mind. We talk about it, we celebrate it, but we don't know the truth, the real truth, which I'm about to share with you tonight. So I hope you enjoy the show tonight and the education that's presented here tonight. And I've actually entitled this one other than just Monday Night Law. So it should be embedded there for a while till somebody decides to change it or whatever have we, which I just recently found out on my Facebook page that, well, they decided to delete my description of the videos in the educational series. Now they say they're untitled. I don't know how that happened, but it did and has. So, with no further ado, like to point out that if you'd like the channel here and like what I'm doing here and want to help support, pay the bills and keep this stuff going, I'd greatly appreciate it. Over at the office at 6477 West Fairview Avenue, Suite C, Boise, Idaho, 83704. Through the snail mail is about the only way to do that anymore, being as I got shut down on PayPal and Cash App, which I will deal with that at another point in time when I have less things on my plate to deal with. I'll go after PayPal and such, and especially those who are claiming that they did that. Kind of funny how that happened, but no. So I do want to thank everybody who has supported in the past and is a continual supporter over there on Patreon. Patreon's going great, and lots of good things going on over there. So if you want to help support in a different way and get in on our Wednesday night workshops, some of the stuff that I can't talk about on here, I can talk about over there in the private. So again, that's moving more towards tier 3 and tier 4 for Wednesday night workshop. So check out the Patreon over there, of course, kirkslawcorner.com. I have different PDFs and all that good stuff going on over there. You can check out the library on the kirkslawcorner.com and download all sorts of documents from there for your reading, which I cover on the show, depending on what it is. But a lot of what I cover on the show, sometimes I'll read from, is published over there for your convenience. And of course, I want to thank all of the people behind the scenes that help make all this happen, that help with Kirk's Law Corner, the team, everybody here right now that's working to make this all happen and keep the trolls at bay. And we just can't stand you people. You're so freaking delusional. It's not even funny. But here we are. I know nothing about the law, but I'm about to read from the law that I don't know nothing about. So, are you ready for some real truth, real history, facts of law, history of law? We're going to go back in time. We're going to go back to 1774. October 14th, 1774. This is the declaration and resolves of the First Continental Congress. This is when we were having some problems with the British Parliament, claiming powers of right to bind the people of America by statute in all cases whatsoever. So, whereas, since the close of the last war, the British Parliament claiming a power of right to bind the people of America by statutes in all cases whatsoever, hath in some acts expressly imposed taxes on them, and in others under various presences, but in fact for the purpose of raising a revenue. Hath imposed rates and duties payable in these colonies, established a board of commissioners with unconstitutional powers, and extended the jurisdiction of courts of admiralty. Now we're going to see this pattern right here, extending the jurisdiction of courts of admiralty, not only for collecting the said duties, but for the trial of causes merely arising within the body of a county. So again, extending that admiralty jurisdiction beyond its ancient limits is unlawful, unconstitutional, and extending those powers under the jurisdiction of admiralty onto the people. And whereas in consequence of other statutes, judges who before held only estates at will in their offices have been made dependent on the crown alone for their salaries, and standing armies kept in times of peace. And where it has lately been resolved in Parliament that by force of a statute made in the 35th year of the reign of King Henry VIII, colonists may be transported to England and tried thereupon accusations for treasons and misprisons, or concealments of treasons committed in the colonies, and by a late statute, such trials have been directed in cases therein mentioned. And whereas in the last session of Parliament, 3 statutes were made. Now, here's the thing. Back then, what were statutes were declarations or constitutions. Not like the statutes we're thinking of today. Those aren't even statutes that they're making today. It's all pretended acts of legislation, which is in the Declaration of Independence. We'll get to that. One entitled, "An Act to discontinue in such manner and for such time as therein mentioned, the landing and discharging, lading, or shipping of goods, wares, and merchandise at the town and within the harbor of Boston in the province of Massachusetts Bay and New England." Another entitled, "An Act for the better regulating the government of the province of Massachusetts Bay and New England." And another entitled, "An Act for the impartial administration of justice in the cases of persons questioned for any act done by them in the execution of the law, or for the suppression of riots and tumults in the province of the Massachusetts Bay and New England." And another statute was then made for making more effectual provision for the government of the province of Quebec, etc., all which statutes are impolitic, unjust, and cruel, as well as unconstitutional, and most dangerous and destructive of American rights. And whereas assemblies have been frequently dissolved, contrary to the rights of the people, when they attempted to deliberate on grievances and their dutiful, humble, loyal, and reasonable petitions to the crown for redress, have been repeatedly treated with contempt by His Majesty's ministers of state. Now, I want to point out right here that, and whereas assemblies have been frequently dissolved, and we're talking about petitions. So we're supposed to be able to call our legislative assembly in to assemble by and through a petition to consult for our common good and to instruct our representatives. Now, you'll notice that some of the things that have changed in our form of government is based on the things that I'm going to show you and read from tonight. This is the reasons why they created our form of government the way they did. They'd had enough. They were tired of Great Britain's usurpations of power, creating statutes that are impolitic, unjust, and cruel, as well as unconstitutional, and most dangerous and destructive of American rights. The good people of the several colonies of New Hampshire, Massachusetts Bay, Rhode Island, and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Newcastle, Kent, and Sussex on Delaware, Maryland, Virginia, North Carolina, and South Carolina, justly alarmed at these arbitrary proceedings of Parliament and administration, have severally elected, constituted, and appointed deputies to meet and sit in General Congress in the city of Philadelphia, in order to obtain such establishment as that their religion, laws, and liberties may not be subverted. Whereupon the deputies so appointed being now assembled in a full and free representation of these colonies, taking into their most serious consideration the best means of attaining the ends aforesaid, do, in the first place, as Englishmen, their ancestors in like cases have usually done, for asserting and vindicating their rights and liberties, declare that the inhabitants of the English colonies in North America, by the immutable laws of nature, so we have the immutable laws of nature, the principles of the English Constitution, which we're referring to is the Magna Carta or Magna Charta, and the civil charters or compacts, have the following rights. Here it is again. We're having to lay down the law, putting the smack down on these are our rights. Get off of our rights, our property. You're trespassing on our property. Again in history. So let it be resolved here that they are entitled to life, liberty, and property, and that they have never ceded to any foreign power whatever a right to dispose of either without their consent. That our ancestors who first settled these colonies were at the time of their immigration from the mother country entitled to all the rights, liberties, and immunities of free and natural born subjects within the realm of England. Number 3, that by such immigration, they by no means forfeited, surrendered, or lost any of those rights, but that they were, and their descendants now are, entitled to the exercise and enjoyment of all such of them as their local and other circumstances enable them to exercise and enjoy. Number 4, that the foundation of English liberty and of all free government is a right in the people to participate in their legislative council. And as the English colonists are not represented, and from their local and other circumstances cannot properly be represented in the British Parliament, they are entitled to a free and exclusive power of legislation in their several provincial legislatures, where their right of representation can alone be preserved. In all cases of taxation and internal polity, subject only to the negative of their sovereign, in such manner as has been heretofore used and accustomed, but from the necessity of the case, and a regard to the mutual interest of both countries, we cheerfully consent to the operation of such acts of the British Parliament as are bona fide, restrained to the regulation of our external commerce, Admiralty jurisdiction, for the purpose of securing the commercial advantages of the whole empire to the mother country and the commercial benefits of its respective members, excluding every idea of taxation, internal or external, for raising a revenue on the subjects in America without their consent. The Stamp Act, the Tea Act. Okay. That the respective colonies are entitled to the common law of England, and more especially to the great and inestimable privilege of being tried by their peers of the vicinage, according to the course of that law, the common law. That they are entitled to the benefit of such of the English statutes as existed at the time of their colonization, and which they have by experience respectively found to be applicable to their several local and other circumstances. Now remember, I have previously covered in that other document over there about how we only adopted certain parts of the English common law. Not all of it. Not all of it applies in America at the time. None of it applies today. We have our American common law, not the English common law. Two totally separate bodies of law. And one does not have to do with the other, with the exception that whatever was adopted at the time, not today. Any statutes or anything like that made, even back in this time, not all of them applied here in America. We had our own legislature. We had our own representatives. We had our own due process of law. And notice it says again that they are entitled to the benefit of such of the English statutes as existed at the time of their colonization. Now we're talking about clear back to the early 1600s. Okay? Because the first charter of Virginia was 1605. I know a lot of people were taught the Mayflower Compact, but that wasn't until 1620. There are several charters and other documents that came before the Mayflower Compact. Number 7, that these, His Majesty's colonies, are likewise entitled to all the immunities and privileges granted and confirmed to them by royal charters. That's some of those things I'm talking about. Were secured by their several codes of provincial laws. That they have a right peaceably to assemble, consider of their grievances, and petition the king, and that all prosecutions, prohibitory proclamations, and commitments for the same are illegal. In other words, to petition the king, Now, we've had this right to petition. And see, notice that the right to peaceably assemble has to do with the petition and grievances. Because that's what the right of assembly is about, is to call them into assembly, to consult for our common good and to instruct our representatives. How is that done? By petition. We have to petition the legislature for the redress of grievances. And when we do the petition, it calls them into assembly so they can assemble peacefully so that we can consult for our common good and all political powers inherent in the people. We have the power to instruct our representatives. They are the servants. They do what we tell them to do in accordance with due process of law and our rights, the common law. They have to follow what we tell them to do. They're the servants, we are the masters. This is what is different about our form of government, is this power exchange, the shift in power. Who has the power now? We do. All of it. Absolutely no power exists in government. Only that which we delegated, and we first must possess that power first in order to delegate a servant to act in that manner, right? And it has to be pursuant to the Constitution, the law of creation. So you get a better view there, but fixed. Now pay attention here, that the keeping a standing army in these colonies in times of peace without the consent of the legislature of that colony in which such army is kept is against law. Now, I know this is going to ruffle some feathers out there, but police forces are armed bodies of men, and it is against the law. We are only supposed to have an army, arm ye, arm you, an armed body of men. That's what army is, an armed body of men. And the only lawful armed body of men in America is organized by the federal government, organized by the state government, and unorganized by government, which is every able-bodied male between the age of 18 to 64 is automatically duty-bound to defend this nation called America from foreign and domestic enemies. We provide for the common defense, not government. We do. Oh, what would we do without police? We would defend ourselves. That comes from the law of nature, naturally, fundamentally, and principally, to defend our life, our liberty, our property from all things that may cause injury, loss, or harm to the people. We have the right to come to the aid and defense of our fellow man, because again, that's providing for the common defense. And the military is subordinate to that authority. Now, the word police is actually supposed to be pronounced policy. Now, I've showed that in several other constitutions in 1776 back in the day, where it talks about the legislative policy making power. You can't say police in that instance where it's written in the Constitution because it wouldn't make any sense. And I've showed the etymology of the word. It is pronounced, in fact, policy. It is a 3-syllable word. Spell it. Police. C-E, policy, not police. We're getting confused when we say in the 10th Amendment there, or Article the 10th of the Bill of Rights, policing powers. That's policy making powers. Okay. It is against the law, and it was against the law in 1774 already. It is indispensably necessary to good government and rendered essential by the English Constitution that the constituent branches of the legislature be independent of each other. So here's that changing fundamentally a monarchy into our republic. That therefore, the exercise of legislative power in several colonies by a council appointed during pleasure by the crown is unconstitutional, dangerous, and destructive to the freedom of American legislation. I mean, we're talking about it right here already, that it was unconstitutional to do what they did. All in each of which the aforesaid deputies, in behalf of themselves and their constituents, do claim, demand, and insist on, as their indubitable rights and liberties, which cannot be legally taken from them, altered, or abridged by any power whatever, without their own consent, by their representatives in their several provincial legislatures. In the course of our inquiry, we find many infringements and violations of the foregoing rights, which from an ardent desire that harmony and mutual intercourse of affection and interest may be restored, we pass over for the present and proceed to state such acts and measures as have been adopted since the last war, which demonstrate a system formed to enslave America. 1774, folks. Resolved that the following acts of Parliament are infringements and violations of the rights of the colonists, and that the repeal of them is essentially necessary in order to restore harmony between Great Britain and the American colonies. So here we are in 1774, assembled the First Continental Congress and said, kick rocks, Great Britain. In order to restore harmony, we're repealing your SMU. The several acts of George III, chapter 15, chapter 34 and 5, chapter 20. I mean, they're listing out what they've done. Get rid of this crap, which imposes duties for the purpose of raising a revenue in America. Taxation is theft. Extended the power of admiralty courts beyond their ancient limits. Deprived the American subject of trial by a jury. Authorized the judge's certificate to indemnify the prosecutor for damages. That's granting immunity. Can't do that. That he might otherwise be liable to, requiring oppressive security from a claimant of ships and goods seized before he shall be allowed to defend his property, and are subversive of American rights. Okay? So again, here we are talking about extending that admiralty jurisdiction beyond its ancient limits. In 1774, ancient limits. This isn't something new. Not in 1774, and sure in the heck isn't in 2021. Also, 12, an act for the better secure. Okay, here's that. Dockyards, magazines, ships, ammunition, and stores, which declares a new offense in America and deprives the American subject of a constitutional trial by jury of the vicinage by authorizing the trial of any person charged with committing any offense described in the said act out of the realm to be indicted and tried for the same in any shire or county within the realm, instead of in the district previously ascertained by law. Also, the 3 acts passed in the last session of Parliament for stopping the port and blocking up the harbor of Boston, for altering the charter and government of Massachusetts Bay, and that which is entitled an act for the better administration of justice. Also, the act passed in the same session for establishing the Roman Catholic religion in the province of Quebec, abolishing the equitable system of English laws, and erecting a tyranny there, to the great danger from so total a dissimilarity of religion, law, and government of the neighboring British colonies, by the assistance of whose blood and treasure the said country was conquered from France. So again, Catholicism from the Roman Catholic Church, which is filled with pedophiles. Also, the act passed in the same session for the better providing suitable quarters for officers and soldiers in His Majesty's service in North America. Why do we have these standing officers and soldiers in America? That's unlawful. Also, that the keeping a standing army in several of these colonies in time of peace without the consent of the legislature of that colony in which such army is kept is against law. Again, reiterating that. That is unlawful. No, can't have that. That's unlawful. You don't have the consent of the legislature. And at this time, what we're talking about is the legislature had to declare war. We're not supposed to just have these armed bodies of men running around being in a state of being policed by policy, statutes. We already have the law. It's called the common law, the law that is common to all. To these grievous acts and measures, Americans cannot submit, but in hopes their fellow subjects in Great Britain will, on a revision of them, restore us to that state. Again, state is about a state of being, not a territorial landmass, in which both countries found happiness and prosperity. We have for the present only resolved to pursue the following peaceable measures: to enter into a non-importation, non-consumption, and non-exportation agreement or association. Imagine that. To prepare an address to the people of Great Britain and a memorial to the inhabitants of British America. And 3, to prepare a loyal address to His Majesty agreeable to resolutions already entered into. Now, this is on avalon.yale.edu, but they're saying here the sources from the formation documents illustrated of the formation of the Union of the American States. House document number 398, selected, arranged, and indexed by Charles C. Tanzel. So this was in 1927. This document's in there. It's part of history. It's also right here in this book that I have, The Annals of America, Volume 2. Now we're going to move a little ahead in time here. Okay. This is the declaration for the causes and necessity of taking up arms, because they didn't give up. Okay. Same thing. Formation of the Union of the American States, 1927, House document number 398. I believe this was July 5th, 1775. Wait, where is it? It should have been. It's not really given the date here, but I believe right out of my book here, it's July. Declaration of Rights. I want to make sure that I quote this correctly. Pardon me. Thursday, July 6th, 1775. Okay. So July 6th, 1775. Now remember, this was in October, the previous one. Okay. And again, there's other stuff in between here. All sorts of stuff happened, but I'm doing a surrounding the Declaration of Independence and reiterating what the Declaration was really about. The Declaration of Independence was about. And I'm showing you the facts of law. So here we go. July 6, 1775. If it was possible for men who exercised their reason to believe that the divine author of our existence intended a part of the human race to hold an absolute property in and an unbounded power over others, marked out by his infinite goodness and wisdom as the objects of a legal domination never rightfully resistible, however severe and oppressive, the inhabitants of these colonies might at least require from the Parliament of Great Britain some evidence that this dreadful authority over them has been granted to that body. This is where we're at today. Where is your lawful authority to do what you're doing? Because fundamentally and principally here, it's just contrary to the man of sound mind. What's going on here? Let's see, they have been granted that, but a reverence for our Creator, principles of humanity, and the dictates of common sense. Right? Do you have to hit your thumb with a hammer here to know that it's going to hurt? There's supposed to be some modicum of common sense here that must convince all those who reflect upon the subject that government was instituted to promote the welfare of mankind and ought to be administered for the attainment of that end. To promote the welfare of mankind. Not to dictate to mankind what our welfare will be or shall be. No, 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 no. Government was instituted to promote the welfare of mankind and ought to be administered for the attainment of that end. The legislature of Great Britain, however, stimulated by an inordinate passion for a power not only unjustifiable, but which they know to be peculiarly reprobated by the very constitution of that kingdom. See, they were even making statutes that were outside of and contrary to their own constitution. And desperate of success in any mode of contest, where regard should be had to truth, law, or right. So truth, law, right, they're all the same thing. Have at length Deserting those attempted to effect their cruel and impolitic purpose of enslaving these colonies by violence, and have thereby rendered it necessary for us to close with their last appeal from reason to arms. Yet, however blinded that assembly may be by their intemperate rage for unlimited domination, so to cite justice and the opinion of mankind, we esteem ourselves bound by obligations of respect to the rest of the world to make known the justice of our cause. Our forefathers, just a little too far, inhabitants of the island of Great Britain, left their native land. Okay, pay attention here, folks. They left their native land to seek on these shores a residence for civil and religious freedom, trying to separate from the Roman Catholic Church. It's in the Magna Carta of 1215. Trying to separate from the Roman Catholic Church. It's the same thing in history over and over and over and over and over and over again, as many times as I can say over again. It's been the same damn thing over and over and over again. This has been going on since as far back as 400 BC. Surely this is not the first and probably not the last time that we have to address these issues. At the expense of their blood, at the hazard of their fortunes, without the least charge to the country from which they removed, by unceasing labor and an unconquerable spirit, they effected settlements in this distant and unhospitable wilds of America, then filled with numerous and warlike barbarians. Societies or governments vested with perfect legislatures were formed under the charters from the crown, and an harmonious intercourse was established between the colonies and the kingdom from which they derived their origin. The mutual benefits of this union became in short time so extraordinary as to excite astonishment. It is universally confessed that the amazing increase of the wealth, strength, and navigation of the realm arose from this source. Imagine that. Because look how small Great Britain really is. It's a very small chunk of land. Not a whole lot going on over there. So when the people came over here, had their charters, this is what happened, and a harmonious intercourse was established between the colonies and the kingdom from which they derived their origin. The mutual benefits of this union became in short time so extraordinary. Okay? It is universally confessed that the amazing increase of the wealth, strength, and navigation of the realm arose from this source. And the minister who so wisely and successfully directed the measures of Great Britain in the late war publicly declared that these colonies enabled her to triumph over her enemies. So in other words, we aided in them taking somebody else down. Isn't that what's happening today? Has been happening. Well, maybe not directly today, but in the not so distant past, our military service members have been used to fight wars in foreign countries where we don't frickin' belong. That's because we've been owned and controlled by Great Britain. London, Vatican, and DC are the Tri-City states, which have been taken down, by the way. We're going back to 1776, folks. Pay attention to what's going on. And it's time to stand up and fight. We are at war with these very same evil groups of people who think they can just make whatever statute they want and dictate to the people without the consent of us. You don't have that power. We hold all the power, not you folks. Your servants. And servants do not dictate to their masters what our rights are and how we decide to exercise those rights. So, as we can see in 1775, towards the conclusion of that war, it pleased our sovereign to make a change in his councils. From that fatal moment, the affairs of the British Empire began to fall into confusion, and gradually sliding from the summit of glorious prosperity to which they had been advanced by the virtues and abilities of one man, are at length distracted by the convulsions that now shake it to its deepest foundations. The new ministry, finding the brave foes of Britain, though frequently defeated, yet still contending, took up the unfortunate idea of granting them a hasty peace and then subduing her faithful friends. This is where we said, okay, all right, we'll grant you peace, which is a different document where they literally laid down their arms and said, okay, we're going to lay down our arms and we'll give you our arms, and we're going to pick up and we're going to leave from here. And as they turned around after laying down their arms, they killed him, shot him, stabbed him in the back. True story, factual, history of law. Study it. Know these evildoers. You do not let your guard down. These devoted colonies were judged to be in such a state of being, as to present victories without bloodshed, and all the easy emoluments of statutable plunder, the uninterrupted tenure of their peaceable and respectful behavior from the beginning of colonization, their dutiful, zealous, and useful services during the war, though so recently and amply acknowledged in the most honorable manner by His Majesty, by the late King, and by Parliament, could not save them from the mediated innovations. Parliament was influenced to adopt the pernicious project. What's that pernicious project? World domination, one world government. And assuming a new power over them, have in the course of 11 years given such decisive specimens of the spirit and consequences attending this power, as to leave no doubt concerning the effects of acquiescence under it. Are we going to quit acquiescing to these unlawful powers, usurpations of powers delegated under this pernicious project of one world government, one world domination? They have undertaken to give and grant our money without our consent. Though we have ever exercised an exclusive right to dispose of our own property, statutes have been passed for extending the jurisdiction of courts of admiralty and vice admiralty beyond their ancient limits. There it is again. I mean, in history, we keep talking about this admiralty jurisdiction. And in 1775, 1774, ancient limits. Now, I don't know how many people are aware of this, but Congress in 1845 extended admiralty jurisdiction onto the land again. They did exactly Well, we declared the causes and necessity of taking up arms and why we started all of this back in the mid to late 1700s. Why we started this back in 1600s. Why we started this back in the 1200s. Why we started this back in 600 AD. Again, over and over and over again. It's the same shit. For depriving us of the custom and estimable privilege of trial by jury. Not jury trial. It is trial by a jury, not a jury trial. In cases affecting both life and property. Now, when we talk about life, we're talking about our sons and daughters. Property being an aggregate of guaranteed rights. Those unalienable rights that you cannot place a lien upon. Those are creator endowed rights. Not inalienable or not unalienable. These are unalienable rights. They are our property. Okay. For suspending the legislature of one of the colonies, for interdicting all commerce to the capital of another. Now, this would be a driver's license, a fishing license, a hunting license. You're interdicting all commerce onto the people. Because fishing is a commercial term. You know, where you go and gather a bunch of fish and take it to the market. Hunting, right? Hunting and trapping was one of the other ones, terms. We need to have a license for that. Yes, to go out there and take from the land and sell it at the market is acting in commerce. Otherwise, you're foraging for food. You're not fishing, you're not hunting, you're foraging for food. Proper diction, jurisdiction from the common law. We are at liberty to feed ourselves from the land, from the water, not the sea, the water. Law spelt L-A-W, land, air, and water. And for altering fundamentally the form of government established by charter and secured by acts of its own legislature solemnly confirmed by the crown. See, that pernicious project came in and went, crap, we're doing pretty good off of these guys. We need to tax them more. We need to take that power from them because they're going to get out of control, out of their control, which is essentially what has happened. We were able to get away from them to a certain extent, starting in 1603 with the establishment of Jamestown, Virginia. First Charter of Virginia of 1606. For exempting the murders of colonists from legal trial and in effect from punishment. For erecting in our neighboring province, acquired by the joint arms of Great Britain and America, a despotism dangerous to our very existence, and for quartering soldiers upon the colonists in time of profound peace. It has also been resolved in Parliament that colonists charged with committing certain offenses shall be transported to England to be tried. But why should we enumerate our injuries in detail? By one statute it is declared that Parliament can, of right, make laws to bind us in all cases whatsoever. What is to defend us against so enormous, so unlimited a power? Not a single man of those who assume it is chosen by us, or is subject to our control or influence. But on the contrary, they are all of them exempt from the operation of such laws. And American revenue, if not diverted from the ostensible purposes for which it is raised, would actually lighten their own burdens in proportion as they increase ours. In other words, theft from us. We saw the misery to which such despotism would reduce us. We for 10 years insistently and ineffectually besieged the throne as supplicants. We reasoned, we remonstrated with Parliament in the most mild and decent language. So there is remonstrance, remonstrated with Parliament. That is saying, no, your statutes are unconstitutional. They're unlawful. They're illegal. No, that's a remonstrance. Administration sensible that we should regard these oppressive measures as free men ought to do, sent over fleets and armies to enforce them. The indignation of the Americans was roused. It is true, but it was the indignation of a virtuous, loyal, and affectionate people. A Congress of delegates from the United Colonies was assembled at Philadelphia on the 5th day of last September. We resolved again to offer an humble and dutiful petition to the King, and also addressed our fellow subjects of Great Britain. We have pursued every temperate, every respectful measure. We have even proceeded to break off our commercial intercourse with our fellow subjects. As the last peaceable admonition, that our attachment to no nation upon earth should supplant our attachment to liberty. This, we flattered ourselves, was the ultimate step of the controversy, but subsequent events have shown how vain was this hope of finding moderation in our enemies. These people will not stop. Period. They just keep coming and coming and trying again over and over and over and over again. These people are not of sound mind. They are insane. They do not possess logic and reason. They don't care. They want what they want, and they'll kill as many people as they so choose until we stop them again. But I believe this is what Trump was talking about, that he wants to wipe these people off the face of the earth. But we'll see. Several threatening expressions against the colonies were inserted in His Majesty's speech. Our petition, though we were told it was a decent one, and that His Majesty had been pleased to receive it graciously and to promise laying it before his Parliament, was huddled into both houses among a bundle of American papers, and there neglected. The Lords and Commons, in their address in the month of February, said that a rebellion at the time actually existed within the province of Massachusetts Bay, and that those concerned with it had been countenanced and encouraged by unlawful combinations and engagements entered into by His Majesty's subjects in several of the other colonies, and therefore they besought His Majesty that he would take the most effectual measure to enforce due obedience to the laws and authority of the Supreme Legislature. So in other words, They hid the petition for redress of grievances from the king and said, nah, we got a bunch of insurrectionists over there. We need to go take them out. We need to take care of them. So even the king was lied to. See, this is that bar, the Crown Temple bar. Soon after, the commercial intercourse of whole colonies with foreign countries and with each other was cut off by an act of parliament. By another, several of them were entirely prohibited from the fisheries in the seas near the coast, near their coasts, on which they always depended for their sustenance, and large reinforcements of ships and troops were immediately sent over to General Gage. Fruitless were all the entreaties, arguments, and eloquence of an illustrious band of the most distinguished peers and commoners, who nobly and strenuously asserted the justice of our cause, to stay or even to mitigate the heedless fury with which these accumulated and unexampled outrages were hurried on. Equally fruitless was the interference of the city of London, of Bristol, and many other respectable towns in our favor. Parliament adopted an insidious maneuver calculated to divide us, to establish a perpetual action of taxations where colony should bid against colony, all of them uninformed what ransom would redeem their lives. So, what are we talking about there? Or what are they talking about there? Parliament adopted an insidious maneuver calculated to divide us. This is those police forces that we have now. Their calculated maneuver to divide us. Well, it's the law. I'm just doing what I'm told. When in fact, one, they're not supposed to exist, these armed bodies of men outside of the military. Number two, to deceive the people in believing that they're law enforcement officers. This would be that erecting a multitude of new offices, sending hither swarms of officers to harass our people and eat out our substance that's in the Declaration of Independence. They're not supposed to exist in our form of government. That is fundamentally altering our form of government. It's a declared act of tyranny. Right? To establish a perpetual action of taxations where colony should bid against colony. Those are them. Bills of attainder, bills of pains and penalties. All of them uninformed what ransom would redeem their lives, and thus to extort from us at the point of the bayonet the unknown sums that should be sufficient to gratify, if possible to gratify, ministerial rapacity, with the miserable indulgence left to us of raising, in our own mode, the prescribed tribute. What terms more rigid and humiliating could have been dictated by remorseless victors to conquered enemies? In our circumstances, to accept them would be to deserve them. To be politically correct, tyrants, and none other. Soon after the intelligence of these proceedings arrived on this continent, General Gage, who in the course of the last year had taken possession of the town of Boston in the province of Massachusetts Bay and still occupied it a garrison on the 19th day of April, sent out from that place a large detachment of his army, who made an unprovoked assault on the inhabitants of the said province at the town of Lexington. As appears by the affidavits of a great number of persons, some of whom were officers and soldiers of that detachment, murdered 8 of the inhabitants and wounded many others. From thence the troops proceeded in warlike array to the town of Concord, where they set up another party of the inhabitants of the same province, killing several and wounding more, until compelled to retreat by the country people suddenly assembled to repel this cruel aggression, which is why we have the right to keep and bear arms, and that right shall not be infringed, just in case some jackwagon gets a hair up his ass and grabs a bunch of men and starts running around our cities and towns and starts frickin' killing people. We're supposed to be able to step outside and defend ourselves. Not calling the police, which isn't supposed to exist, and expect them to defend us. No. We have the right to defend ourselves. We don't need an armed body of men to do it for us. Hostilities, thus commenced by the British troops, have been since prosecuted by them without regard to faith or reputation. The inhabitants of Boston, being confined within that town by the general, their governor, and having, in order to procure their dismission, entered into a treaty with him, it was stipulated that the said inhabitants, having deposited their arms with their own magistrate, should have liberty to depart, taking with them their other effects. They accordingly delivered up their arms, but in open violation of honor, in defiance of the obligation of treaties, which even savage nations esteemed sacred, the governor ordered the arms deposited as aforesaid, that they might be preserved for their owners, to be seized by a body of soldiers, detained the greatest part of the inhabitants in the town, and compelled the few who were permitted to retire to leave their most valuable effects behind. Told you they were betrayed. It's right here in history. By this perfidy, wives were separated from their husbands, children from their parents, the aged and the sick from their relations and friends who wish to attend and comfort them, and those who have been used to live in plenty and even elegance are reduced to deplorable distress. Are they using different tactics today? I think so. The general, further emulating his ministerial masters, by a proclamation bearing date of the 12th day of June, after venting the grossest falsehoods and calumnies against the good people of these colonies, proceed to declare them all, either by name or description, to be rebels and traitors, to supersede the course of the common law, and instead thereof to publish and order the use and exercise of the law martial. His troops have been butchered. His troops have butchered our countrymen, have wantonly burnt Charlestown, besides a considerable number of houses and other places. Our ships and vessels are seized. The necessary supplies of provisions are intercepted, and he is exerting his utmost power to spread destruction and devastation around him. How about them lockdowns we've been going through for over a year, shutting businesses down, shutting the trade off? Our internal trade, not external trade. We have received certain intelligence. The Governor Carleton, the governor of Canada, is instigating the people of that province and the Indians to fall upon us. And we have but too much reason to apprehend that schemes have been formed to excite domestic enemies against us. Oh, well, wait a minute. I thought we just came in here and annihilated all the Indians and took their land and all that stuff. That's not exactly what happened. Sorry. In brief, a part of these colonies now feel, and all of them are sure of feeling, as far as the vengeance of administration can inflict them, the complicated calamities of fire, sword, and famine. We are reduced to the alternative of choosing an unconditional submission to the tyranny of irritated ministers or resistance by force. The latter is our choice. We have counted the cost of this contest and find nothing so dreadful as voluntary slavery. Honor, justice, and humanity forbid us tamely to surrender that freedom which we received from our gallant ancestors, and which our innocent posterity have a right to receive from us. We cannot endure the infamy and guilt of resigning succeeding generations to that wretchedness which inevitably awaits them, if we basely entail hereditary bondage upon them. Our cause is just. Our union is perfect. Our internal resources are great, and if necessary, foreign assistance is undoubtedly attainable. We gratefully acknowledge, as signal instances of divine favor towards us, that his province would not permit us to be called into this severe controversy until we were grown up to our present strength. We had been previously exercised in warlike operation and possessed of the means of defending ourselves. With hearts fortified with these animating reflections, we most solemnly, before God and the world, declare that exerting the utmost energy of these powers, which our beneficent Creator hath graciously bestowed upon us, the arms we have been compelled by our enemies to assume, we will, in defiance of every hazard, with unabating firmness and perseverance, employ for the preservation of our liberties, being with one mind resolved to die free men rather than to live slaves. Lest this declaration should disquiet the minds of our friends and fellow subjects in any part of the empire, we assure them that we mean not to dissolve that union which has so long and so happily subsisted between us, and which we sincerely wish to see restored. Necessity has not yet driven us into that desperate measure, or induced us to excite any other nation to war against them. We have not raised armies with ambitious designs of separating from Great Britain and establishing independent states. We fight not for glory or for conquest. We exhibit to mankind the remarkable spectacle of a people attacked by unprovoked enemies, without any imputation or even suspicion of offense. They boast of their privileges and civilization, and yet proffer no milder conditions than servitude or death. In our own native land, in defense of the freedom that is our birthright, and which we ever enjoyed till the late violation of it, for the protection of our property, acquired solely by the honest industry of our forefathers and ourselves, against violence actually offered, we have taken up arms. We shall lay them down when hostilities shall cease on the part of the aggressors, and all danger of their being renewed shall be removed, and not before. With a humble confidence in the mercies of the supreme and impartial judge and ruler of the universe, we most devoutly implore his divine goodness to protect us happily through this great conflict, to dispose our adversaries to reconciliation on reasonable terms, and thereby to relieve the empire from the calamities of civil war. Preliminary work of Thomas Jefferson, John Dickinson, Morrison, Samuel Eliot, Henry Steele. There's some other people there. This is documents illustrated of the formation of the Union, the Confederacy, because a union is a league of friendship, which is a confederacy of the American states. Now, here is the document that separates us from Great Britain, not the Declaration of Independence. This is the Lee's Resolutions, June 7th, 1776. Resolved that these united colonies are, and of right ought to be, free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is, and ought to be, totally dissolved. That it is expedient forthwith to take the most effectual measures for forming foreign alliances, that a plan of confederation be prepared and transmitted to the respective colonies for their consideration and approbation. There you have it. And thank you again, Mark. Federalist Papers 6, 9, 43, and 45, 43 and 45 in caps, a Confederate Republic. Our form of government is a capitalist Confederate Republic. Not a representative democracy, not a democracy in any way, shape, or form. Oh, but we vote. Yeah. In a Republican form of government, not a democracy where the mob rules. You got to have 2/3 vote, and then they only have certain subject matter jurisdiction. There is a limited form of government here. This is the document that separates us from Great Britain, not the Declaration of Independence. That's a lie. Now, notice the date, June 7th. Now let's go to the next document, the first document of our new nation. That would be the Virginia Declaration of Rights as the theoretical foundation of all government, like it says in my book right here. That's this document right here. This lays down the law of this nation, new nation called America. This is it. This is June 12th, 1776. Which, by the way, this document was fully ratified July 2nd, 1776. But what happens in between? We have to declare the new nation called America, which is this document right here, followed by this document. Okay. And I'll read from my book here. The top portion of this doesn't seem to be here. Well, I guess it wouldn't be top portion. It would be something that was written about it. Virginia's Declaration of Rights was in many ways a central document of its era. Imagine that. It's the first one of the new nation, ain't it? Drawn upon by Jefferson for the opening paragraphs of the Declaration of Independence. Huh. It was widely copied by the other colonies, became the basis of the Bill of Rights in the Constitution, and had considerable influence in France at the time of the French Revolution, which I'm going to show you a document about that. It was written by George Mason and adopted by the Virginia Constitutional Convention on June 12, 1776, as the theoretical foundation of all government. Now, the only thing that they've changed here at avalon.law.yale.edu, different from the book that I have that's published here, they changed this particular section right there. That in all capital criminal prosecutions, man has the right to demand the cause and nature of his accusation, to call for evidence in his favor, and to a speedy trial by an impartial jury of 12 men of... Oh, where's the 12 men? Why is that not there? Of his vicinage, without whose unanimous consent he cannot be found guilty. You do not have to get unanimous consent to find you innocent. It's without whose unanimous consent he cannot be found guilty. Let's see. I got this thing here. Uh-oh. I got it before they changed it. See back here, back in the day? Back in 2007? The Avalon Project, the Constitution of Virginia. Well, this contains... Now see, again, this is not the Constitution. This is a Declaration of Rights separate from the Constitution. But it was laid down first. Declaration of Rights made by the representative of the good people of Virginia, assembled in full and free convention, which rights do pertain to them and their posterity as the basis and foundation of government. Imagine that. They removed that from Avalon. This is the Bill of Rights, June 12, 1776. This is the Virginia Declaration of Rights. As the theoretical foundation of all government. Because remember, Virginia was established in 1603. It was first. And Virginia actually encompassed 7 of the other colonies at the time. Well, I should say 6 other colonies, total of 7 out of Virginia. 7 states were made out of Virginia. And again, I'll read from my book here when it talks about the Virginia Constitution, which is going to blow your mind, because over here, and I'll just show you this here. Back to this. That in all capital and criminal prosecutions, a man hath the right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses, to call for evidence in his favor, and to a speedy trial by an impartial jury of 12 men of his vicinage, without whose unanimous consent he cannot be found guilty. Now, when we go back over here, I'm going to show you how that's been removed. Speedy trial by an impartial jury. Where is the of 12 men? They don't want us to know that it's supposed to be by 12 men, so that they can deceive us and say, oh, well, we can do a trial by jury less than 12. No, you cannot. This is the law that was laid down in 1776, which was already the law going back to 1166 with the disease of Clarendon. But now, this is law.cornell.edu, and I'll back up just to show you again. This is under the Sixth Amendment, right? We'll come over here. Your right to speedy trial. Right to speedy trial. Speedy trial. Source and rationale. Now, the Magna Carta declared, and this has been altered as well, because I copied and pasted from this back in, I don't know, 3 years ago in Tony Pellegrino's case into a document that I created for him. And this used to say what the original Magna Carta of 1215 said, is to no man will we deny, to no man will we sell, to no man will we deny or delay justice and right. But pay attention. This is the source and rationale, logic and reason here, of the history of the right to a trial by jury. Or, oh, well, this is the right to a speedy trial. Yeah, what kind of a speedy trial? By an impartial jury of 12 men of our vicinage, without whose unanimous consent you cannot be found guilty. But look, this is the annotated Constitution here, talking about what it said in the Constitution and the succession of law. Much the same language was incorporated into the Virginia Declaration of Rights of 1776. Why is that? Now, look what it's citing there. 7F Thorpe, the Federal and State Constitution, House Doc number 357, 59th Congress, second session, number 8, 3813, in 1909. Now, wait a minute. And from there into the Sixth Amendment. Well, when we come back over here, and to a speedy trial by an impartial jury of 12 men of his vicinage. That's within the same part of the sentence between the two commas. So how can they not know, when looking at this for the right to a speedy trial, how can you not know how a trial by jury works within the same sentence, within the same commas, the same portion of the sentence? Okay. This is, again, why I'm pointing this out, is it's showing succession of law. Why does our rights make a stop at the Virginia Declaration of Rights? Because it's the theoretical foundation of all government. Our right to a republican form of government. That all men are by nature equally free and independent and have certain inherent rights, of which, when they enter into a state of society, wait a minute, state of society, a state of being, that's right, they cannot, by any compact, deprive or divest their posterity, namely the enjoyment of life and liberty, with the means of acquiring and possessing property, and pursuing and obtaining happiness and safety. That's a right retained by the people. Then all power is vested in and consequently derived from the people. That magistrates are their trustees and servants, and at all times amenable to them. You are servants. That government is, or ought to be, instituted for the common benefit, protection, and security of the people, nation, or community. Of all the various modes and forms of government, that is best, which is capable of producing the greatest degree of happiness and safety, and is most effectually secured against the danger of maladministration, and that whenever any government shall be found inadequate or contrary to these purposes, a majority of the community hath an indubitable, unalienable, and indefeasible right to reform, alter, or abolish it in such manner as shall be judged most conducive to the public weal. Now, that no man or set of men, that's you bar members, are entitled to exclusive or separate emoluments or privileges from the community, but in consideration of public services, which not being descendable, neither ought the office of magistrate, legislator, or judge be hereditary. Theoretical foundation of all government. We're not supposed to have sets of men with different emoluments than the people. Now, I've showed this from the commentaries on the Constitution by Joseph Story. This particular section in talking about the no titles of nobility, because it sets up different classes of people, and it would be an odious claim, a skanky claim. Well, I have a license to practice law. No, you do not, because we didn't authorize that. We didn't give our consent to our servants in government to create the bar. So it's void for any effect from its inception. 1878, the American Bar Association. Unlawful, unconstitutional, not authorized. Not to mention the original Article the 13th. These are articles in addition to an amendment to the Constitution of the United States of America, not the Constitution of the United States. The Constitution of the United States of America, the real one, not your fraudulent one from United States Inc., which has been recently foreclosed on and terminated in 2012. Now, the legislative and executive powers of the state should be separate and distinct from the judicative, and that the members of the two first may be restrained from oppression by feeling and participating the burthens of the people. They should, at fixed periods, be reduced to a private station, return into that body from which they were originally taken, and the vacancies be supplied by a frequent, certain, and regular elections in which all or any part of the former members to be again eligible or ineligible as the law shall direct. Okay. were supposed to return back to a private station and return into that body from which they originally were taken and have new elections. That elections of members to serve as representatives of the people in assembly ought to be free, which means can't hold a title of nobility, and that all men having sufficient evidence of permanent common interest with and attachment to the community have the right of suffrage and cannot be taxed or deprived of their property for public uses without their own consent or that of their representatives so elected, nor bound by any law to which they are not, in like manner, assented for the public good. Like the Idaho Code. We did not give you permission to create the bar. We didn't give you the permission to delegate the legislative power, our power, to a set of men called the Code Commission to write these books and publish them and call it the Idaho Code, which is not the law. See Peterson versus Peterson, Idaho Supreme Court, 2014, Judge Eisman. The Idaho Code is not the law. It's not law at all. It's not even a codification of the law. It's a bunch of garbage made up by a bunch of members of the bar. Get this crap out of my republic. That all power of suspending laws or the execution of laws by any authority without consent of the representatives of the people is injurious to their rights and ought not to be exercised. Now, that one little sentence destroys what the governors did in 49 states. That power doesn't exist in our form of government. Now, we already read that one a couple times. That excessive bail ought not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Sounds quite familiar there, don't it? How about this one? That general warrants whereby any officer or messenger may be commanded to search suspected places without evidence of a fact committed, or to seize any person or persons not named, or whose offense is not particularly described and supported by evidence, are grievous and oppressive and ought not to be granted. They're not supposed to have general warrants where, well, anywhere in Idaho you can execute this warrant. No, that's not how warrants work. The warrant has to describe the particular person or place to be searched or seized and the things to be seized. It's required pursuant to the common law, due process of law. Now, wait a minute. What's this? That in controversies respecting property and in suits between man and man, the ancient trial by jury is preferable to any other and ought to be held sacred. Would that mean a trial by jury of 12 men of our vicinage? Yep, it sure would. And yes, now that we're right here at this particular point in time in reading this document, the treatise on arrest and false imprisonment by Charles Wiseman. It's on kirkslawcorner.com. Free to download over there. The It talks about this stuff, the process that is due. Now, Mark, if you read that 6 men in Idaho, it says with the consent to less than 12. That's right. Got to read it. You got to, and they actually have a form there that both parties, or whoever the parties are to the case, are supposed to fill out and file with the clerk and file with the court that they consent to less than 12. All right, so here's a really good one for some people that might not know about this particular right. That the freedom of the press is one of the greatest bulwarks of liberty and can never be restrained but by despotic governments. Let me repeat that again. That the freedom of the press is one of the greatest bulwarks of liberty and can never be restrained but by despotic governments. That's right. Period. It cannot be restrained. Now, what is this one? That a well-regulated militia composed of the body of the people trained to arms is the proper, natural, and safe defense of a free state. That standing armies in time of peace should be avoided as dangerous to liberty, and that in all cases, the military should be under strict subordination to and be governed by the civil power. That's us. Imagine that. So when it says a militia being necessary for the security of a free state, this is where they got it from. Well, you have to be in the military for that. No, this is what it says here. A well-regulated militia composed of the body of the people trained to arms is a proper, natural, and safe defense of a free state, a state of being free and equal. That the people have a right to uniform government, and therefore that no government separate from or independent of the government of Virginia ought to be erected or established within the limits thereof. That no free government or the blessings of liberty can be preserved to any people but by a firm adherence to justice, moderation, temperance, frugality, and virtue, and by frequent reoccurrence to fundamental principles. You know, the fundamental principles that we cannot alter because it's a principle like 2 + 2 = 4. Let's look at that fundamental principle here. That religion, or the duty which we owe to our Creator and the manner of discharging it, can be directed by reason and conviction, not by force or violence. And therefore, all men are equally entitled to the free exercise of religion according to the dictates of conscience, and that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other. This is why the First Amendment, or first article of the Bill of Rights, says Congress shall make no law respecting the establishment of religion, as I just previously covered, that they tried to reestablish the Roman Catholic Church, Catholicism in Quebec at the time. Where do you think they got the idea to put that in there? Because we declared Christianity is our religion, our theoretical foundation of all government here in America. Okay? There it is, as it is written. Now notice, they don't have at the bottom there the same thing that they used to have, because they took it away from there, because they altered it. And so they didn't want to get in trouble for altering it. Wait, where is it? I thought it showed it there. I know in my book it cites 7S Thorpe right here. Oh, Thorpe the 7th, page 3812 through 3814. Now, I believe this does have its source as well. See, this is the Virginia Constitution that they will not, it's not on here. Oh, yeah, there we go. Look at that. Now, why isn't that there? Why don't they show the source? And other organic laws of the states. These are organic laws. The law of creation. Now or heretofore forming the United States of America. Francis Newton Thorpe. Now, this is the same when we go back over here that this is talking about. 7F Thorpe, Federal and State Constitutions, House Doc number 357, 59th Congress, second session, 1909. Now, why isn't it here? They used to have it down there, and this was done from this website back in 2007. Here's the source that was listed back then. Why did they take it off? Because they altered that document and removed the 12 men. The right to a trial by jury of 12 men of our vicinage? Yeah. Because they're hiding that from us. They don't want us to know that that's how that right works. But there's two different places I'm showing you the actual source of this document as the other organic laws of the states, territories, colonies now here to forming the United States of America. Yeah, compiled and edited under the Act of Congress of June 30th, 1906 by Francis Newton Thorpe. Which now, remember, that other one shows it right here. Now, this is a 1927 House Document 398. That one's House Document number 398. Now, this is a draft of the Constitution for Virginia. Now, notice they got some typos here. But this is the draft. By keeping among us in times of peace, standing armies and ships of war, lacking to render their military independent and superior to the civil power, but combining with others to subject us to a foreign jurisdiction, giving his assent to the pretended acts of legislation, for quartering large bodies of troops among us, for imposing tax on without our... Okay, wait a minute. This kind of sounds like the Declaration of Independence, don't it? But one of the things I want to show you from the actual draft where is it? Oh, here, how about juries? All facts in cases whether of chancery, common, ecclesiastical, or marine law shall be tried by a jury upon evidence given by a viva voce in open. I don't know if I said that right. I know it's viva voce in open court, but where witnesses are out of the colony or unable to attend through sickness or their inevitable necessity, their deposition may be submitted to the credit of the jury. Let's see. How about this one? Fines. All fines or amercements shall be assessed, and terms of imprisonment for contempts and misdemeanors shall be fixed by the verdict of a jury. The jury is supposed to decide that. Otherwise, it would be a bill of attainder or bill of pains and penalties, which is legislation that prescribes punishment. We're supposed to be up to the jury to decide all of that. All process, original and judicial, shall run in the name of the court from which it issues. Now, there it is. No person hereafter coming into this country shall be held within the same in slavery under any pretext whatever. Tell me that they weren't trying to abolish slavery back then? This is the draft of the Virginia Constitution of June 29th, 1776. Yeah, no, they didn't give women equal rights. But if you look at the Bible and how the family's supposed to be, the woman's supposed to stay at home and the husband is supposed to protect his wife and his family. All persons shall have full and free liberty of religious opinion, nor shall any be compelled to frequent or maintain any religious institution. But remember, religion is liberty of conscience. No free man shall be debarred the use of arms within his own lands. Standing armies, there shall be no standing army but in time of actual war. Free press, printing presses shall be free, except so far as by commission of private injury, cause may be given of private action. So you can print whatever you want, freedom of speech, freedom of the press. Being responsible for those actions, right? Okay, now we're going to go back over here because the real one is here. Oh, went way too far. What the heck? I jumped down way too fast. Okay. So here is the Virginia Constitution, June 29th, 1776. Now, before we go into reading from here, I'm going to read from my book, The Annals of America, Volume 2, page 434, the first Virginia Constitution. So let's read what this has to say here. Virginia's was probably the most famous of early constitutions, and it served as a model for other states. As a reaction to the tyranny of the royal governors, the legislature was given virtually all the governing power. Members of the executive and judicial branches were chosen by the House of Burgess. The Provincial Convention drafted this Constitution in May and adopted it on June 29, 1776, without submitting it to a referendum, which at this particular point in time, remember, we're creating the new nation. So we didn't follow those same steps as previous. And again, source, Thorpe 7, page 3814 through 3819. Virginia Declaration of Rights is page 3812 to 3814. So, like in this book, one page right after another. Now, why do they hide the Virginia Constitution? Because this actually lays out our 3 distinct branches of government that I busted Attorney General Barr on his lies. Oh, well, we didn't have a 3 distinct branches of government at the Articles of Confederation. So, that was one of the reasons why we had to do the new Constitution and create these. No, that's a lie. And here's the evidence and proof. I know this is going on, but this is a good one. And I want you to see this because this is where the Declaration of Independence came from. Read. Whereas George III, King of Great Britain and Ireland and Elector of Hanover, heretofore entrusted with the exercise of the kingly office in this government, hath endeavored to prevent the same into a detestable and insupportable tyranny, by putting this negative on laws the most wholesome and necessary for the public good, by denying his governors permission to pass laws of immediate and pressing importance unless suspended in their own operation for his assent, and when so suspended, neglecting to attend to them for many years, by refusing to pass certain other laws unless the persons to be benefited by them would relinquish the inestimable right of representation in the legislature, by dissolving legislative assemblies repeatedly and continually, for opposing with manly firmness his invasions of the rights of the people. When dissolved, by refusing to call others for a long space of time, thereby leaving the political system without any legislative head. By endeavoring to prevent the population of our country, and for that purpose obstructing the laws of naturalization of foreigners. By keeping among us in times of peace standing armies and ships of war, by effecting to render the military independent of and superior to the civil power, by combining with others to subject us to a foreign jurisdiction, giving his assent to their pretended acts of legislation, for quartering large bodies of armed troops among us, for cutting off our trade with all parts of the world, for imposing taxes on us without our consent, for depriving us of the benefits of trial by jury, for transporting us beyond seas to be tried for pretended offenses, for suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases whatsoever, by plundering our seas, ravaging our coasts, burning our towns, and destroying the lives of our people, by inciting insurrections of our fellow subjects with the allurements of forfeiture and confiscation, by prompting our Negroes to rise in arms against us, those very Negroes whom, by an inhumane use of his negative, he hath refused us permission to exclude by law, by endeavoring to bring on the inhabitants of our frontiers, the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions of existence. By transporting at this time a large army of foreign mercenaries to complete the works of death, dissolution, and tyranny, already begun with circumstances of cruelty and perfidy, unworthy the head of a civilized nation. By answering our repeated petitions for redress with a repetition of injuries, and finally by abandoning the helm of government and declaring us out of his allegiance and protection, by which several acts of misrule, the government of this country, as formerly exercised under the crown of Great Britain, is totally dissolved. We, therefore, the delegates and representatives of the good people of Virginia, having maturely considered the premises and viewing with great concern the deplorable conditions to which this once happy country must be reduced, unless some regular, adequate mode of civil polity is speedily adopted, and in compliance with the recommendation of the General Congress, do ordain and declare the future form of government of Virginia to be as forthwith. Now, here we go. The legislative, executive, and judiciary department shall be separate and distinct, so that neither exercise the powers properly belonging to the other, nor shall any person exercise the powers of more than one of them at the same time, except that the justices of the county court shall be eligible to either house of assembly. Imagine that. The legislative shall be formed of two distinct branches, who together shall complete legislature. That's right. The House is consisted of two different branches, the House of Representatives and the Senate. They shall meet once or oftener every year and shall be called the General Assembly of Virginia. One of these shall be called the House of Delegates or the House of Representatives, and consist of two representatives to be chosen for each county. And for the district of West Augusta annually, of such men as actually resided in and freeholders of the same and duly qualified according to law, and also of one delegate or representative to be chosen annually for the city of Williamsburg, and one for the borough of Norfolk, and the representative for each of such other cities and boroughs as may hereinafter be allowed particular representation by the legislature. But when any city or borough shall so decrease, as that number of persons having right of suffrage therein shall have been, for the space of 7 years successively, less than half the number of voters in some of one county in Virginia, such city or borough thenceforth forward shall cease to send a delegate or representative to the assembly. So when they got down low in numbers, they would have to decrease their representation. The other shall be called the Senate. And consist of 24 members, of whom 13 shall constitute a house to proceed on business, for whose election the different counties shall be divided into 24 districts, and each county of the respective district at the time of the election of its delegates shall vote for one senator, who is actually a resident and freeholder within the district, or duly qualified according to law, and is upwards of 25 years of age, and the sheriffs of each county within 5 days of farthest after the last county election in the district shall meet at some convenient place, and from the poll so taken in their respective counties return as a senator the man who shall have the greatest number of votes in the whole district. To keep up this assembly by rotation, the district shall be equally divided into 4 classes and numbered by lot. And at the end of 1 year after the general election, the 6 members elected of the first division shall be displaced, and the vacancies thereby occasion supplied from such class or division by new election in the manner aforesaid. This rotation shall be applied to each division according to its number, and continued in due order annually. Right of suffrage and election. I mean, you can clearly see we laid out our Republican form of government right here, June 29th, 1776. So we have to, understand this, comprehend this in a chronological order of things. The Lee's Resolution, the Virginia Declaration of Rights, the Virginia Constitution, and then the Declaration of Independence. Because this is part of what all took place. And we have to read this, what it says. What does it say here? When in the course of human events, it becomes necessary for one people to dissolve the political bands which have connected them with another. Well, I'll be darned. Wouldn't that be this one? Whoops. No. There we go. Absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is ought to be and totally dissolved. Well, that's what we're talking about here, right? In the course of human events, it becomes necessary for one people to dissolve the political bands. That's what we're doing there, right? That's what we're doing right here. And to assume among the powers of the earth the separate and equal station, the private station, to which the laws of nature and of nature's God entitle them. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to the separation. The Declaration of Independence is not the document that declares our separation from Great Britain. That is the Lee's resolutions that does that document. Okay? This is declaring the causes for the separation, as it is written right there in the very beginning of the Declaration of Independence. What are we declaring our independence from? Tyranny, tyrants, usurpations of power, subversions of law, sedition, conspiracy to deprive rights, treason. That's what this document is about. And we say, we hold these truths to be self-evident. Again, wait a minute. That's some of the same verbiage that was in the Declaration for the Causes and Necessity of Taking Up Arms, isn't it? Yeah, okay. That all men are created equal. Well, that's in the Virginia Declaration of Rights. That's in the English Bill of Rights of 1689. That's in the Magna Carta of 1215. That they are endowed by their Creator with certain unalienable rights. That among these are life, liberty, and the pursuit of happiness. That to secure these rights. Now, again, I know I went over that real fast, but that among these unalienable rights are life, liberty, and the pursuit of happiness. That to secure these rights, these unalienable rights, governments are instituted among men, not men with titles of nobility, not kings and queens and princes and princesses. Now pay attention here. Deriving their just powers from the consent of the governed. Their just powers. They don't get to just take whatever powers they want and assume these powers. That whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it. So again, this is telling us why. Why? The causes for the separation. It is the right of the people to alter or to abolish it and to institute new government. We already instituted the new government. That's in the Virginia Declaration of Rights and the Virginia Constitution. Laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. Remember, the fundamental principles of instituting government is securing our safety and happiness, fundamentally and principally. Prudence indeed will dictate that governments long established should not be changed for light and transient causes. The causes which impel them to the separation are not light and transient. Okay? And accordingly, all experience have shown that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. Now we're at this particular point again, except we already have a form of government written by Constitution. It needs to be read, understood, and supported and upheld. That's what support actually means. We need to hold these people accountable. We don't need to alter the Constitution. We already have a more perfect union. It just needs to be upheld. It needs to be enforced. It needs to be executed, as no man is above the law. And those that are servants are most definitely not above the law. How the heck can they even begin to think that they have some sort of immunity from the law? In no way, shape, or form would we grant immunity from the law, the common law, our rights as the law. No, I don't think so. But when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism. Now, going back to the Declaration for the Cause and Necessity of Taking Up Arms, the pernicious project, that usurpation of power, extending admiralty jurisdiction onto the land again beyond its ancient limits. And let me correct that. It is not natural law. It is the law of nature. It's what it says as it is written. Laws of nature. Right there. Not natural law. It's laws of nature. And again, we go back. I can take you back over here. And show you it's law of nature. is not natural law. This is that bar word salad, taking away the laws of nature and saying that they have the power to make, well, natural law. No, this is off limits, which is in that report of the Commission on Unalienable Rights, is outside of the sphere of governmental control and is in fact our property. Property being an aggregate of guaranteed rights. There it is. Law of nature. The law of nature is that which God, the sovereign of the universe, has prescribed to all men. Not by any formal promulgation, but the internal dictate of reason alone. Imagine that. And it is the law of nature. Now, go back over here, finish this up. That they are endowed by their creator. God is the sovereign, and God endows us with sovereignty. Among those rights, among these unalienable rights, okay? Such has been the patient suffrage of these colonies, which in reading the history there, 11 years they went through some pretty horrific times. And such is now the necessity which constrains them to alter their former systems of government, the monarchy, and the charters that were granted, and the monarchy was subverting their own charters. The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over these states. To prove this, let facts be submitted to a candid world. Again, the Declaration of Independence is not the document that declares our independence from Great Britain. These are the reasons why we separated from Great Britain and why we instituted our new government on June 7th and June 29th. Which again, this is written from the Virginia Constitution, which I just showed you. You're going to, the same stuff. He has refused his assent to laws, the most wholesome and necessary for the public good, right? He has forbidden his governors to pass laws of immediate and pressing importance unless suspended in their own operation till his assent should be obtained. And when so suspended, he has utterly neglected to attend them. It's exactly the same verbiage in the Virginia Constitution. Has refused to pass other laws for the accommodation of large districts of people, unless those people would relinquish the right of representation in the legislature, a right esteemable to them and formidable to tyrants only. These are declared acts of a tyrant. Let these facts be submitted to a candid world. This is a statement of facts. These are not Republican in character or conduct. This is the stuff that is foreign to our form of government and repugnant to our law. Now, do you get a better idea of what the Declaration of Independence is really about? We're declaring our independence from tyranny, from tyrants, and we're declaring what our enemy looks like. And when you give aid to our enemy, that is treason, punishable by death, a capital offense, because the supreme law of the land says so. Now, these are all Almost all of these are in the Virginia Constitution for cutting off our trade with all parts of the world, protecting them by mock trial from punishment for any murders which they should commit on the inhabitants of these states, for quartering large bodies of armed troops among us. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, giving his assent to their acts of pretended legislation. This is why I keep saying, well, that's foreign to our form of government and repugnant to our law, because that's what it's saying right there. It's foreign to our Constitution, our form of government, and repugnant, as in unacknowledged by our laws. It is repugnant to our law. The law that was laid down and, before government was instituted to secure that law. Depriving us of, in many cases, of the benefits of trial by a jury. For transporting us beyond seas to be tried for pretended offenses. Okay? How about for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our governments? That's another place that I get that foreign to our form of government, fundamentally altering our form of government. For suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases whatsoever. He's abdicated government here by declaring us out of his protection and waging war against us. He has plundered our seas, ravaged our coasts, burned our towns, and destroyed the lives of our people. Same stuff in the Virginia Constitution. Now, this is where people stop usually, right? A lot of people stop reading the Declaration of Independence at the end of the second paragraph. But these are all the declared acts of tyranny of a tyrant that's foreign to our form of government. This is not Republican in character or conduct. Now, let's read the bottom portion of the Declaration of Independence that a lot of people do. In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people. Now, wait a minute. Let's read that again. A prince whose character is thus marked by every act which may define a tyrant. This is what the Declaration of Independence is really about, is defining the characteristics and conduct of a tyrant. Nor have we been wanting in our attentions to our British brethren. We have warned them from time to time of attempts by their legislature to extend an unwarrantable jurisdiction over us. Admiralty jurisdiction. We have reminded them of the circumstances of our emigration and settlement here. We left the lands to seek freedom, religious freedom, to be free from Catholicism. We keep reminding them of the circumstances of why we left their garbage. We have appealed to their native justice and magnanimity, and we have conjured them by the ties of our common kindred to disavow these usurpations, which would inevitably interpret our connections and correspondence. They too have been deaf to the voice of justice. Lady Justice, not Lady Liberty. Lady Liberty is the Trojan horse. It's Lady Justice. And of consanguined guint in the essay, that one. We must, therefore, acquiesce in the necessity which denounces our separation and hold them as we hold the rest of mankind, enemies in war, in peace, friends. We, therefore, the representative of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name and by the authority of the good people of these colonies, solemnly publish and declare that these united colonies are, and of right, ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, they have full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states might of right do. And for the support of this declaration, with a firm reliance on the protection of divine providence, we mutually pledge to each other our lives, our fortunes, and our sacred honor. Now, this is signed by John Hancock, and I'm going to read from the book. Well, if I can find it. Well, let's see. Okay, here we go. From the book, Declaration of Independence. Oh, I guess that mouse ain't going to do it. All right. From the Declaration of Independence, out of my book here. I'm going to show you. Top portion. Okay, going to read from that. The Declaration of Independence was formally adopted by the delegates to the Second Continental Congress, meeting in Philadelphia on July 4th, 1776. 2 days earlier, that's right, 2 days earlier, the Lee's resolution was ratified. 2 days earlier, a resolution had been passed which said that these united colonies are, and of right, ought to be free and independent states, that they are absolved from all allegiance to the British Crown, and that all political connections between them and the state of Great Britain is and ought to be totally dissolved. 2 days prior to the Declaration of Independence. Again, the introduction on June 7th of this resolution, that would be the Lee's resolution, June 7th, 1776, right? By Richard Henry Lee, yep, that would be that one, of Virginia, had been followed by the appointment of a committee to draft a statement declaring the reasons for the impending separation. Of the members of this committee, which included Thomas Jefferson, John Adams, Benjamin Franklin, Roger Sherman, Robert Livingston, it was Jefferson who prepared the draft, submitting it to the others for consideration. Minor changes in the Jefferson's draft were suggested by Adams and Franklin. Some further alterations were made after it was presented to the Congress on June 28th. What are we talking about here? That's the Virginia Constitution and the Virginia Declaration of Rights. The final work, however, were still largely those of Jefferson. At its passage, it was signed only by John Hancock. The presiding officer. John Hancock was the presiding officer. 4 days later, the Declaration of Independence was read aloud in the city of Philadelphia at what later became Independence Square. So 4 days later, copies were made, sent to the legislature of the colonies, and published throughout the country. The Declaration was not signed by the other members of Congress until August 2nd, when a copy egressed on parchment was witnessed with their names. So, technically speaking, the Declaration of Independence was not ratified until August, and I thought it was August 8th, August 2nd, 1776. So, now that you've been educated on the history surrounding the Declaration of Independence, there's a lot more to the Declaration of Independence than just the Declaration of Independence. A lot more. And hopefully I clarified that today as I showed you the letter of the law as it is written from the documents themselves. And exposed Avalon from altering the one document and completely hiding the Virginia Constitution. It's listed on Avalon, but when you click on it, it says it's not available. Why are you hiding that document? Because they don't want us to know how our form of government was created, when it was created, and put all of these pieces of the puzzle together. That's why. So, where are we at, America? Where are we at? Not just, here's the thing, is this isn't just America, right? These people are so sick and evil. This has been in their plan and the works since 400 BC. And that's BC, not AD. 400 BC. Okay? This is worldwide, folks. These people have been trying to take over the world for a long time. Over and over and over again. The same old shit. Over and over and over again. Period. So the next time you hear somebody talking about, the Declaration of Independence, wrong. And as I posted on Facebook and everywhere, correction, it was the Lee's resolutions that separated us from Great Britain, not the Declaration of Independence. The Declaration of Independence declares acts of a tyrant. It defines the characteristics and conduct of our enemy. And giving aid to our enemy is treason. That's why I call him out for treason. So, you want to start standing up for real and actually do something about it? One, you can file a petition, not a remonstrance, a petition, because a petition is a political lawsuit and it goes to the legislature, not the judicial. Number two, in the executive branch, you can file a criminal complaint. And you can thank Trump for the joint task force that he created for us to do this. All these new attorney generals. We're not stuck with just one state attorney general and one federal attorney general. No. Trump created a task force filled with attorney generals. for us to file criminal complaints with. That's under Texas v. White, Article 4, Section 4, guaranteed Republican form of government to protect us from invasion and domestic violence, which is internal insurrection, an attempt to overthrow the Constitution and war against the people. Domestic violence doesn't have anything to do with family. Okay? It has to do with them usurping their powers and doing, again, extending admiralty jurisdiction beyond its ancient limits. Okay? Then in Texas v. White, it says that, well, at the conclusion of the war, Civil War, that, well, the president has the authority to institute temporary government until Congress can be assembled. Where do you think we're at right now, folks? Why do you think Trump said we're going back to 1776? We're at war. We've been at war. There has been no declaration of peace since 1861. Trump is the first de jure president since Lincoln. Pay attention, folks. Where's the Declaration of Peace? There ain't one. And again, Russell J. Gould, 1999. Okay? Captured the flag, which captured the world. In 2012, the United States Inc. was foreclosed on and terminated. But Obama didn't want to give that up. Trump got elected by the people. That's right. Trump is the first de jure president since Lincoln. Why do you think Trump's done everything that he has done? Does this paint a little bit different picture? From his proclamation on December 10th of 2017 to all of his executive orders, making amendments to the manual for courts martial. Yeah. This is what's coming, folks. It's already been happening. Why do you think the military was there at the White House, surrounded the White House, surrounded D.C.? Because those were the insurrectionists. Okay? This is what's coming, or I should say, has already come. It's already happened. It's already happening. There are mass arrests that have been made in the last 2 years. Lots of them. And just because you haven't seen them, just because you're not aware of them, doesn't mean that it hasn't happened. That it isn't happening. Save the children. This is way more than just save the children. This is save the world. This is save America, the true intent of our founders. And we're taking down the deep state cabal, right? That's what's going on. This isn't about just save the children. So all of you family law people out there that are, well, save the children, save the children. Come on, people, wake up. It's more than just the children. Our fundamental principles that we're grateful to Almighty God for the blessings of liberty. Among those unalienable rights. Okay? All right. So now, this will conclude Monday Night Law on Kirk's Law Corner. And if you'd like to help support the channels, both Facebook and YouTube, and I still have not had a chance to get signed up on a couple of other places that I want to yet. But I'd greatly appreciate it because I pretty much work off of donations, right? Everything I'm doing here. Do this for free. Taking my time out of my day to educate the masses. And again, this isn't just for America, right? Because this is a fundamental principle of law worldwide. We've all been subjected to this stuff. We're the last ones standing with arms. It's up to us. And again, I do not advocate for violence. So unless you're prepared to follow due process of law and file either a petition into the legislature, not a remonstrance, a petition, or criminal complaints with the executive branch, because like it says in Article 4, Section 4, on application of the legislature, and if the legislature or the executive, if the legislature cannot be convened for domestic violence. And Luther versus Borden specifically states that this is a political argument, not a judicial one. The judicial branch does not have subject matter jurisdiction. None. Not even under original jurisdiction. Sorry, none. It's not how our form of government works. We redress our grievances with the legislature. And if the legislature cannot be convened, as in they won't assemble peaceably, so that we can consult for our common good and we can instruct our representatives to alter, reform, or abolish whatever shit made up they have created because we say so, then we go to the executive with a criminal complaint and we let the executive branch do their job. And if they don't, well, then it's time to take up arms. But at all times, we have the right to keep and bear arms, which shall not be infringed, to defend our life, our liberty, and our pursuit of happiness. Make no mistake, we already have that right. And it's been retained, laid down, ordained, and established. Everybody should know this as self-evident, pursuant to the laws of nature, that we have the right to defend our life and shun that which may cause injury, loss, or harm to us, fundamentally and principally, from the laws of nature. We don't even need the Second Amendment. It comes from the law of nature, naturally, fundamentally, and principally. So, on that note, folks, happy Independence Days. Because remember, these fireworks that are going bang, 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 bang is supposed to be a reminder of the cannon fire from the ships bombarding our coastline and trying to knock out our flag and our fort. Now think about all the mess that we had to clean up back then. All of the dead bodies and all the rubble from destruction of cannonballs and cannon fire. Lighting stuff on fire in buildings and raping and pillaging our women and children. You know what happened to a lot of the men, the 56 men that signed that Declaration of Independence? Yeah. Their houses were burned. Their wives and children were raped and murdered. Burned their farms and their animals, killed their animals, destroyed anything and everything. That's why we stand when the national anthem is played, in remembrance of the people that gave their lives, their fortunes, for us to be free. What freedom we have left today. Yeah, they paid the ultimate sacrifice. So make sure you stand up for the national anthem. Make sure you stand up for your pledge of allegiance to the flag of the United States of America, to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all, no matter what your skin color is. That's the founding principles, the theoretical foundation of all government of this nation called America. Because we're grateful to Almighty God for our blessings of liberty. All right. Much love, everybody. Thanks for being here, especially people outside of America. We're fighting. We're trying to do something. Everybody is worldwide. Just saying. Things are happening all over the world, folks. You may not know about it, but it is. Lots of arrests. People in foreign governments have all resigned. I mean, there's so much stuff going on, folks. Believe me, one day you'll see it. You'll be forced to see it. We're not going to see it all. Probably about 20%. But anywho, much love. And Patreons, we'll see you over there on Patreon Wednesday night workshop. And of course, Friday night fun night. Much love, everybody. Have a good night.